Court will call 24 CM 176, State of Wisconsin versus Ryan Borgwardt. State appears by District Attorney Jerisa Spisa. The defendant appears in person with Attorney Eric Johnson. The court's been handed a plea questionnaire. The defendant will be pleading no contest to the charge of obstructing an officer. Joint recommendation for 45 days in the county jail, Huber privileges, work release privileges, court costs, and a DNA sample. Is that the offer from the state?
That is, along with the payment of the costs pursuant to Wisconsin Statute 973.06, in paren 1 and paren AV, negotiated in the amount of $30,000 that was deposited with the Clerk of Court's office last week.
Attorney Johnson, is that your understanding of the agreement?
It is, Your Honor.
Mr. Borgwardt, is that your understanding?
It is.
I have a plea questionnaire form. Did you go over this form with your attorney?
I did.
Did you understand it?
I did.
I'm going to go over it with you also. It says you'll be pleading no contest to the charge of obstructing an officer. Is that correct?
Correct.
You are 45 years old, 17 years of schooling. You do have a high school diploma or equivalency. You understand the English language and the charge to which you are pleading. Is that correct?
Correct.
You are not currently receiving treatment for a mental illness or disorder and have not had any alcohol, medications, or drugs in the last 24 hours. Is that correct?
Correct.
By entering your plea, you're giving up several constitutional rights. Your right to a trial, to remain silent, and understand your silence could not be used against you at trial, to testify and present evidence at trial, to use subpoenas to require witnesses to come to court and testify for you, to a jury trial where all 12 jurors would have to agree you're either guilty or not guilty, to confront in court the people who testify against you and cross-examine them, and to make the state prove you guilty beyond a reasonable doubt. You understand these rights and that by entering this plea, you are giving up those rights?
I do.
There are several elements to the charge. The state would have to prove each element beyond a reasonable doubt before you could be found guilty. You obstructed an officer. The officer was doing an act in an official capacity. The officer was acting with lawful authority. You knew the officer was an officer acting in an official capacity and with lawful authority, and you knew your conduct would obstruct the officer. Do you understand those elements?
I do.
I'm not bound by any agreement. I can sentence you to the maximum penalty. In this case, a $10,000 fine and 9 months in the county jail. Do you understand that?
I do.
If you're not a citizen of the United States, your plea could result in deportation, the exclusion of admission to this country, or the denial of naturalization under federal law. Do you understand that?
Yes.
If I accept your plea, I'll find you guilty of the charge of obstructing an officer. Do you understand that?
I do.
Other than what has been said here today, has anybody made any threats or promises to get you to plead here?
No.
Have you had enough time to think about this?
Yes.
Have you had enough time to discuss this case in the plea agreement with your attorney?
Yes.
Do you have any questions?
I do not.
Do you understand what we're doing here today?
Yes.
Knowing all of this, do you still wish to plead no contest to the charge?
Yes.
Attorney Johnson, did you go over the plea questionnaire with your client, including all of the rights your client's giving up, elements of the crime, and potential penalties?
I did.
Did you discuss this case in the offer with him?
Yes.
Do you believe he's entering his plea knowingly, voluntarily, and intelligently?
He is.
Court approves the waiver, finds the defendant is entering his plea knowingly, voluntarily, and intelligently. Is the state using the criminal complaint for a factual basis?
Yes, please.
Any objection?
No.
Based on that, the court finds there is a factual basis for the plea based on the complaint. The court will find you guilty as charged, order a judgment of conviction be entered here today. With regards to sentencing, other than the parties, is there anybody who wishes to address the court? Hearing nothing, what does the state have to say?
Thank you, Your Honor. We now know that in the late evening of August 11th of 2024, the defendant arrived in Green Lake, Wisconsin, and put in motion the final steps to his plan of faking his death so that he could disappear from his everyday life of being a husband and father in Wisconsin and realize his selfish and self-centered plan to travel overseas to be with a woman that he met online. Months earlier, defendant began the extensive planning to execute this perfect plan to disappear from his normal life. He took out a sizable life insurance policy. Defendant transferred money overseas. He regularly communicated with the woman, professing his love and desire to create a new life with her. He reversed his vasectomy. He applied for a replacement passport, claiming that his original one, which his wife found in the family safe in its normal place, was lost or stolen. He researched and studied how to successfully disappear. He looked into how to fake a drowning and chose our beautiful lake, Green Lake, which his research revealed would make his ruse more believable. He believed that Green Lake's great depth would mean that a body would not surface. According to the defendant, his entire plan to fake his death, to devastate his family in order to serve his own selfish desires, hinged on him dying in the lake and selling his death to the world. His words. What defendant didn't count on was the great concern and dedication of the Green Lake County community and the dogged resolve of our law enforcement. For 58 days, the Green Lake County Sheriff's Department, with the support and assistance from community members, Bruce's Legacy, the Wisconsin Department of Natural Resources, cadaver dogs, deep divers, fishermen, local businesses, regional and national law enforcement partners searched for the defendant. The defendant's family was left to believe that he was missing or worse, dead. Meanwhile, law enforcement was determined to help his family find closure and left no stone unturned, looking into any and all resources in an attempt to determine his fate. Through the use of national and international law enforcement tools, 58 days after the defendant faked his death, this investigation pivoted. Law enforcement discovered that on August 13th of 2024, the defendant was encountered in Canada. Law enforcement would continue to dig and find that the defendant flew from Canada into Europe, where he then went to the country of Georgia. Once there, he began to create a life with the woman he met on the internet, getting a job and an apartment. The defendant continued to covertly monitor the news to ensure that he was successful in faking his death. He took extra precautions while overseas so as to not leave a digital footprint that could lead to his discovery. Once again, the defendant did not count on the determination and dedication of our law enforcement. Beginning on November 8th of 2025, 89 days after the defendant faked his death, the Green Lake Sheriff's Office began a months-long electronic communication with the defendant. Chief Deputy Vandekoek talked with him by electronic communication. The defendant admitted to his ruse. He admitted to the work he did, purchasing an e-bike, abandoning his vehicle, ditching the kayak on the lake along with his tackle box that had his driver's license in it and his fishing rod, stashing that e-bike night to the Madison area, where he dumped that e-bike in a park and later boarded a Greyhound bus which took him to Canada, flying then overseas to accomplish his goal. The Sheriff's Department continued to communicate with the defendant for approximately 1 month, convincing him to return to Wisconsin to account for and 121 days after the defendant put his plan into action, he returned. He is now convicted of the Class A misdemeanor of obstruction for knowingly placing physical evidence with the intent to mislead officers in the performance of their duties. Wisconsin in paren 1 and paren AV allows this court to impose the reasonable costs expended by a state or local law enforcement agency or emergency response agency to respond to or investigate the false information that the defendant provided or the physical evidence that the defendant placed. Costs allowed under this paragraph may include personnel costs and costs associated with the use of police or emergency response vehicles. The total amount of recoverable costs in this case, pursuant to that statute, were calculated at $51,127.05. The state calculated this amount only for the time period beginning August 11th of 2024, when the defendant faked his death on our lake, up until that 58th day when that investigation pivoted, when we discovered that he'd been encountered in Canada, and then shifted that investigation. That was the term of the obstruction. The total amount recoverable for the two departments that most actively were involved in the investigation were the Green Lake County Sheriff's Office in the amount of $35,522.73, and the Wisconsin Department of Natural Resources, $15,604.32. This is the total amount recoverable by the statute, but certainly not the total costs of all the work done by community and federal partners. The parties have agreed upon the resolution that the court is aware of, based upon the factors that the court must take. Today's date was to pay the $30,000 that we negotiated, that will be split between the Sheriff's Department and the DNR to cover their costs for the investigation into the obstructing. That was done last week. This defendant's egregious obstruction, along with the parties' joint recommendation for 45 days in jail, court costs, and a DNA sample, is the recommendation that I stand behind and I'm asking the court to follow. Prior to today's date, Your Honor, the defendant had no prior criminal convictions. He now has a conviction for a crime of dishonesty. Certainly, any criminal charge, conviction, and sentence that this court today hands down will not be able to come close to undoing the incredible damage that this defendant, by his premeditated selfish actions, has done not only to his family, but our community. The destruction to his family can never be undone. For months, this defendant executed a series of plans that led to his children, his wife, his family, our dedicated officers, our community, our partners to believe he was dead. And while a misdemeanor conviction, along with 45 days in jail and payment of a portion of the costs expended by our law enforcement to discover his devastating act, cannot begin to fix the damage he has done, it tells our community that we will hold individuals accountable and may also act as a deterrent to future destructive plans such as this. Those that may wish to disappear are on notice that our community will not give up after a few days. We will continue to dig, and if we find that a crime has occurred, we will work to hold you accountable. Your Honor, I ask that the court follow the joint recommendations of the parties. Sentence the defendant to, along with the Huber privileges, impose court costs, and accept the DNA sample.
Is there anything else you wish to say?
Briefly, Judge. This is obviously a very unique case that he made initially. However, I think he's made some really good and positive decisions after those events. All of the decisions boil down to one thing, and that is that he is here taking responsibility for his actions. When he first retained me, obviously I had to look at everything and advise him of the options he had moving forward. Those options were to take a litigation path or to see if there was some way that we could amicably resolve this. Option one, obviously from a legal standpoint, was quite interesting due to the facts and circumstances surrounding this case and whether or not a jury would believe that the conduct that he engaged in warranted a criminal conviction. But he did not want to go down that path. And as we see here, the attention, he did not community into that. He wanted to accept responsibility for his actions. He came back from Europe to take responsibility from his actions, and for his actions, and I think that that's worth noting as well, because this was a non-extraditable misdemeanor. If he didn't want to come back, he didn't need to come back. As the state has pointed out, and as the court is aware, he's repaid a significant amount of money for the costs associated with this per statute. He's 45 years old. He has no prior factors. This makes sense. As to the gravity of the offense, it's a simple misdemeanor. Ultimately, Ryan character and rehabilitative needs. Other than this isolated incident, there's nothing to indicate any prior criminal history. There's nothing to indicate that any Department of Corrections needs to be involved in any way, shape, or form. He's working, he's taking care of his obligations to his family. He's continuing. The state has discussed danger to the community. I think perhaps what he did warrants some punishment, and is why we are agreeing that the 45-day jail term is appropriate. So I think based upon all of those factors, this is an appropriate recommendation for the court to follow it.
Is there anything you wish to tell the court, sir?
And all the pain. Friends.
An appropriate sentence, the seriousness of the offense, the protection of the public, the needs of the defendant. Clear, the defendant is not being sentenced on faking his death. That is not a crime in the state of Wisconsin. It is up to the legislature to determine if it should be a crime and what, if any, penalty there should be for it. The defendant is facing a sentence on the crime of obstructing an officer. This is typically for someone who gives a false name or misleads an officer. It is not a serious crime, but it is a drain on police resources. In this case, the spend time and resources. Now, the defendant has said he didn't think law enforcement would search for him as long as they did. But the point is, the defendant's actions, faking his death, required the sheriff's department to expend resources to search for him, and that obstructed law enforcement. The public. The court doesn't believe this is a factor in this case. The third factor the court looks at is history, and has already paid the county $30,000 towards the cost expended in the search for the defendant. He is here accepting responsibility. This leads the court to believe rehabilitation is not an issue in this case. The court recognizes the parties have come to an agreement on 45. However, the court notes there were 89 days from the date the defendant was declared missing on August 12th until the email from the sheriff's department to the defendant on November 8th. It was during these 89 days that the defendant faked his death, and then, when he realized law enforcement knew he had not drowned, days. He could have come forward before that time, but he decided not to. A factor the court can consider for sentencing is deterrence for the defendant and anyone else who is thinking about faking their death. If you persist in your deception, the longer you obstruct, the longer you are duplicit, instead of coming forward and admitting your mistake, the longer the penalty should be. The court determines that the appropriate he allowed his deception to continue. Therefore, the court sentences the defendant to 89 days in the county jail. The court grants Huber privileges, out-of-county service and travel, 60 days to report. The court also orders court costs paid within 60 days or set up a payment plan with the clerk of court. The defendant must submit a DNA sample. The money paid by the defendant shall be released to the sheriff's office and DNR as they agree upon. The defendant is entitled to 2 days of Attorney Johnson?
I don't believe so. Thank you, Judge.
Thank you.